Hi, everyone. Welcome back. We are now moving on out of the chapters talking about parties to crime and in-show crimes. And now we're going to move on to specific crimes against people. So make sure that you did your exam, you completed your exam, and we're now moving on to a whole nother segment of information. Okay, so let me share my PowerPoint. So now we are going to move into even more specific crimes. So although we did talk about parties to crime and crimes against persons, parties to crime, and then we talked about in-show crimes, which were specific crimes. We're going to get into more of what we would consider the traditional crimes. So rape, murder, burglary, those kinds of crimes. So that's what we're moving into. So when you talk about crimes, you can break them down into different categories. So crimes are considered either violent crimes or non-violent crimes. So violent crimes are what we consider crimes against people, okay? So if a person is injured in some way, that's considered a violent crime. There's another category that's considered non-violent crimes. So those are usually what you would classify as property crimes. And then there's some other different categories of crimes that can fall under that, like morality crimes, public order crimes, crimes against the state. So some of those things would also fall under nonviolent crimes. Now, some of those, like terrorism, obviously can be a violent crime if somebody's hurt, but we're going to lump that into these other crimes, okay? So this is just for fun, so you can see when you talk about crime occurs all the time, right? So when you were in intro, we talked about the uniform crime reports, and we said how many of these crimes are actually committed. So when you take all of those crimes and divide it by how many minutes and seconds are in a year, you can get a rough estimate about how frequently these crimes occur. So it doesn't mean they actually occur this quickly, but it's giving you some reference. So there's a violent crime every 22.4 seconds. There's a murder every 31 minutes. There's a forcible rape every 5 minutes and 5.8 minutes. There's a robbery every 1.2 minutes. And there's an aggravated assault every 36.8 minutes. So you can kind of see the frequency based on the number of these that are committed each year. So what we're going to do is we're going to start this week with talking about homicides. So we are going to go over the definition of homicides. So one of the things I want to point out, which I've been kind of doing anyway with the parties to crime and the in-show crimes, is that I'm going to go over what the common law definitions are, what the general definitions of these are, which is what we did. And then we will look specifically at New York, just like we did with parties to crime and in-show crimes. Though when I taught you parties to crime and in-show crimes, the definitions ended up being very, very similar to the New York crimes. New York kind of followed along. When we get to homicides, you're going to see that the definitions kind of do vary. So New York is going to be pretty specific, and every state's homicide laws are going to be pretty specific. Okay, so the first thing we have to do is we need to define the term homicide. So a homicide is defined as one person taking the life of another human. So this is a very, very general definition. So when you watch the news or anything and they say there was a homicide, what they're saying is just one person took somebody else's life. It doesn't say it's criminal. It doesn't say it was an accident. It doesn't say it was justified. It's just one person taking the life of another. So homicide is just the title of any time that happens. But then you can break those down into different categories. So you do have what are called justifiable or excusable homicides. So these are when you have a valid justification or excuse. So these would be like the things we talked about: killing in self-defense, killing when you're insane. So they're forms of homicides, but they're justifiable or excusable, so you would not have to go to jail for them, okay? And then you have the criminal ones. So these are the ones that are actually considered crime, where you have no valid justification or you have no excuse. Other justification or excuses would be if you are the executioner and giving out the death penalty, things like that, or killing in a war. So those are things that don't qualify as criminal, even though they are one person taking the life of others. Since we're in criminal law, we're going to be focusing on the criminal homicides. Okay, so just like we did with the other crimes, we need to break the crimes down into their elements. So the term homicide itself can be broken down into its element. So when you look at the Actus Reyes for homicide, the Actus Reyes is an act or omission. So if you don't do something you're required to do, that takes the life of a human being or a person. Okay, so for Actus Reyes, if you're going to charge somebody with a certain level of homicide, you have to show that they did something or didn't do something they were required to do. That act took somebody's life, and that they took the life of a person, not an animal or something like that. Now, just like all Actus Reyes, the acts have to be voluntary. The person has to voluntarily commit them. Otherwise, you would have a valid defense, and you may not be able to prove Actus Reyes. So let's look at this then. Josephine is an unmarried 21-year-old. She gave birth while sitting on the toilet. She did not call for help and left the baby in the toilet while she pushed out the placenta. She finally removed it from the toilet by its feet, placed it in the floor, cut the umbilical cord with a razor. The baby was limp and made no cry. She left the baby on the floor, cleaned herself and the room, wrapped the baby and laid it in the tub and went back to sleep. The mother found the baby in the morning, and the baby was no longer alive. So is this a homicide? Is this one person taking the life of another person? So we have to figure out, number one, did she take the life, right? And number two, is the baby considered a person under the law? So what about this one? And how is this one different? Cotton accidentally shot his girlfriend, who was 8.5 months pregnant. The baby was born, but died 2 days later from lack of blood between the time that the mother was shot and the baby was born. Is that a homicide? So again, one person, Cotton, taking the life, yes, of a person. So is a baby, if it's born and only lived 2 days, is it a person? So we have to figure out, how does the law define the term person? And I'm not trying to get controversial or get into any political debates, but this is an issue that has to be resolved, because you cannot charge somebody with a homicide unless that person is unless that is defined as a person. So how does the law solve this problem? Well, under common law, there was a rule that was called the born alive rule. So the born alive rule required that to be a person, the baby had to actually be born, come out of the mother, and actually be alive. So actually take a breath. So it was not considered a person until it came out of the mother and it actually took a breath. Okay? So that was the born alive rule. So don't shoot the messenger if you don't like this. That's just what common law, how they defined a person. So when we look back in the first one, we don't know if the baby is a person. We would have to do an autopsy and maybe get a medical examiner. And we would have to look, did the baby take a breath? Was there oxygen in the baby's lungs? If so, then it could be a homicide. If not, if you can't show that the baby ever took a breath, then it was not considered a homicide. Now, in the second example, clearly the child took a breath. It lived for 2 days. So that could be qualified as a homicide under the born alive rule. So what you see sometimes is how people define person can affect the abortion rules in any given state. So this was prior to them passing that actual statute against abortion, but this was a bill that if you had an abortion, it was punishable by death. So clearly they were defining an infant inside the womb still as a person, okay? So some states try to classify people as the fetus still inside the mother. And therefore, if you have an abortion, it could be taking the life of another person, which could be a homicide. And then we'll talk about the levels of homicide. And they want to make it the hardest homicide, the highest that was eligible for the death penalty. So this born alive rule ultimately has a huge significance on the issue of abortion. Because if you say that the fetus inside of a mother is a person already, then that's how you can then start to criminalize abortion, okay? So let's look at New York. So while under the influence of drugs, Paul Santoro drives his car down Main Street, 60 miles per hour. Mrs. Hand, who is 30 weeks pregnant, steps off the curb and is struck by Santoro's speeding car. Mrs. Hand suffers a miscarriage. So you have to decide, is her fetus inside of her a person in New York? Because remember, you cannot charge homicide unless the fetus meets the definition of person. So we need to look up the definition of person. So hint, look up the definition of homicide, look up the definition of person. So stop the video, look it up, and see if you can find how the New York penal law defines person. So hopefully you found it. Now, this is a really newly changed law, because what used to be the definition is homicide was taking the life of a fetus. I think it was 28 weeks or further. That was considered a person. But the actual person definition said born alive. So we had two inconsistent sections of the New York penal law. They were not consistent with each other. So New York just recently rewrote it, and now New York firmly stands on the born alive rule. So you cannot charge somebody in New York for any level of homicide for a fetus that's still in the mother. Okay, now that is when you're born and become a person. Now we have to think of the other end of the spectrum. When is a person no longer a person? So what if a person is in a coma and the only thing keeping that person alive is life support and there's no brain activity? So the only thing that's functioning is a machine beating their heart and breathing for them, but their brain is not functioning at all. Is that still a person? Because if it is, and you take that person off life support, that's a form of a homicide. And you could be charged with that if you were a doctor, a nurse, or a medical technician, or anything like that. So the law had to determine, when are you no longer considered a person? When do you cease being a person? And what the courts have said is one or the other. So irreversible cessation of circulatory and respiratory function. So that means your heart stops beating. So the only way it's beating is the machines. That would be no longer a person. Or complete cessation, irreversible cessation or stopping of all brain activity. Okay, so if you have zero brain activity, that is also when you cease being a person. So under common law, if either one of these are fulfilled, you could end life support and it would not be considered a homicide because you no longer fit the definition of person. So that is the discussion for this week. Is it a homicide or is it physician-assisted suicide? So we need to think about these things. When you're talking about homicide, when does it become a homicide? When is it physician-assisted suicide? So how do we distinguish between these, and when can we actually charge somebody for this type of thing? So that is the Chapter 9 discussion. Okay, so homicide, we said Actus Reyes, one person taking the life of another, but don't forget crimes also have mens rea. So we need to figure out what the mens rea would be for the term homicide, okay? Now, mens rea is going to depend on what level of homicide that we're talking about. So homicide is the big broad definition, and then we have different crimes, layers of homicide underneath. So under common law, they broke homicide into two categories, murder and manslaughter. So if you intentionally killed somebody, then that fell under murder. So you actually intended, intentional, that was murder. But if it was non-intentional, so like a reckless or a negligent, even a knowing, that fell under the category of manslaughter. So these were the only two main categories of homicide that existed. So the mens rea for a murder would be intentional, and manslaughter would be either reckless, negligent, or knowing. So it would be a lower level. So in order to know what the mens rea is going to be, you have to figure out what level of crime, of homicide, that you're actually going to charge. Now, we also talked, when we went over elements, our wheel and all the elements, one of the elements we talked about was causation. And we haven't talked about that much because it's really not a significant issue in many of the crimes. But when it comes to homicide, causation is a very, very important, significant issue. Causation is the idea that you have to show that the defendant caused the death. Okay, so but for the defendant's actions, this person would no longer be dead. Okay, so it becomes a very, very significant element when you're talking about homicides. So you're most likely going to have a medical examiner testify to why the person died, what was the cause of death. And then you're going to have to link the defendant to that cause of death. So you're going to have to prove causation in these cases. And it's a really important element when you're talking about homicide. So think of it in this case. What if you hit someone and it puts them into a coma, and the man lives for 366 days and then dies? Can you be charged with murder? So the question is, did this person cause the death? Now, the victim lived for over a year. So can we still connect back what happened that actually led to the death, or did something else? Maybe the person developed cardiac disease or cancer or something like that along the way. What actually caused the person to die? Now, under common law, if a person lived over 1 year and 1 day, then you could no longer prove causation. The court said it's too long of a period. So you can no longer link the death back to the actions. It's too far apart. But they have changed that with modern medicine and autopsies and all of the things that they can do. Now, length of time does not matter. As long as you can have a medical examiner or a doctor testify of what they died of, and that was linked back to the defendant, you can still prove causation and still convict somebody of homicide. So New York does allow this to go on before longer than 1 year and 1 day. Now, what about this? Fred shoots Carrie and she's being rushed to the hospital with life-threatening injuries. While in the ambulance, a car runs a red light and crashes into the ambulance. All the people in the ambulance die, including Carrie. Is Fred criminally liable for homicide? Okay. So the question is, did Carrie die from the gunshot, or did Carrie die from the ambulance crashing? What caused Carrie's death? So if you want to charge Fred with murder, now you might be able to charge him with attempt because obviously he was dangerously close proximity to success. He actually shot her, or a severe level of assault. You can do that. But can we actually charge Fred with the actual murder? So remember, we have to show causation. We have to show that it was Fred's gunshot that killed Carrie. So how would we do that? We would have to have a medical examiner testify that she would have died from the gunshot wound, regardless of the car accident. Okay? What about this? Derek attacks, rapes, and stabs Wendy. When Wendy is rushed to the hospital, they learn she has lost a lot of blood, but she is Jehovah's Witness, so she refuses a blood transfusion. She later dies. So we want to prove causation. Can we show that Derek caused Wendy's death? What did she die of? Did she die of the stab wound? Was it life-threatening? Or did she die because she refused a blood transfusion? So we have to link her death back to Derek and not to any other causes. If it can be linked to another cause, then it's going to be hard to prove that Derek's guilty of murder. Now, don't forget, you can always reduce the charges and charge attempted murder, but can we charge them with the actual murder? So these all involve what we call an intervening act. So this is when the defendant does something and then the victim dies, but in between those two things, something else happens. There's an act that occurs. And an intervening act can break the causation between the defendant's act and the death. Okay? Now, if what the defendant did is, or if the person dies based on what they did and it's naturally and foreseeable that if you do X, it could lead to death, then you may be able to get around it. But you have to show that it's a natural and foreseeable consequence. So maybe in the first one, where Fred shoots Carrie, it is natural and foreseeable that somebody could die when you shoot them. And it may be natural and foreseeable when the ambulance has to rush them to the hospital so they don't die, they could get in an accident. So you may be able to still prove that Fred caused the death because it could be a natural and foreseeable consequence. But maybe not so much on this case, right? It is natural and foreseeable if you stab somebody, they could die. But is it natural and foreseeable that the victim is going to refuse a blood transfusion that could save her life and then she dies? This would be a much harder case to prove against Derek. So in this case, you may have to drop to attempted murder. Now, what about this? Terrence and Eddie get into a fight on top of a 10-story building. Eddie pushes Terrence off the building. As he is falling to his death, his wife sees him falling and shoots him in the head out the window because she found out he was cheating on her. Who is liable for this homicide? Which one caused the death? So now we have to decide, did he die because he was pushed off the building? Or did he die because he was shot in the head? Which one actually caused his death? So if you're a medical examiner, is there any way you're ever going to be able to determine this? Probably not, right? You're probably never going to be able to totally figure this out. So we have a test called substantial factor test. So sometimes multiple things happen and the medical examiner can't conclusively say what caused the death. But the medical examiner can say that they both were a substantial factor that led to the death. If what you do is a substantial factor, even if we can't prove that it actually caused the death, you can still be responsible, okay? So you can be responsible for a substantial act. So shootings, when multiple people shoot and you have multiple gunshot, what if you can't prove which one did it? Those would be situations where it's still a substantial factor. You're still a substantial factor in causing the person's death. Then you can still hold them criminally liable, okay? Now, the last element we have to talk about with homicide is harm. So what is always going to be the harm in a homicide? What's the harm that is suffered? Well, it's always going to be death, right? So the harm is always going to be one person takes the life of the other. So the harm is death. The one person is going to die. Now, sometimes you hear people talk about this additional element of homicide, and it's called Corpus Delecti. So Corpus Delecti means the body of the crime. And a lot of times people refer to that as the body. So we have to show that a person died. What's the only way to show that a person died? We have to have a body. So a lot of people think Corpus Delecti means body. It really doesn't. It means you have to prove all of the elements of the crime, the body of the crime. Every element on our wheel has to be proven. That's Corpus Delecti. But with homicides, one of those elements is death, and you generally have to have a body in order to prove that element. So what about this? Jack gets into a fight with Gary and punches Gary in the face. Gary decides to walk away. When leaving, he passes out and dies. The autopsy shows he had a heart attack. Jack is charged with homicide. So based on all of the elements, mens rea, actus reus, causation, harm, which one of these was probably missing? So why would it be hard to prove homicide in this case? Well, it would be hard to show causation. So he does intentional act, he does punch him, but can we show that the punch is what caused the death? No, because the medical examiner is going to testify that he had a heart attack. Is it natural and foreseeable that if you punch somebody, they're going to have a heart attack? No. So I don't think you could probably prove causation. Paula is driving. She hears her phone bing, so she looks down and checks her text message. When she is reading, she doesn't see a man walking into the street. She hits and kills him. She is charged with an intentional homicide. Okay, so we have to think of the elements again. Mens rea, actus reus, causation, harm. So do we have harm? Yes. Death. Was it her actions that caused that death? Yes. So we have causation. Did she commit a criminal act of taking the life of another person? Yes. She killed a man. But then we get to intentional. Can she be charged with an intentional homicide? Probably not. So you're probably not going to be able to prove the mens rea for an intentional homicide. Now, if it was a homicide with a lower level of mens rea, like a reckless or a negligent, you might be able to charge her, but you could not charge her with an intentional crime because she doesn't have intent. Henry kidnaps Larry. He's failing to pay a gambling debt. Henry sends a ransom note to Larry's parents so that he can try to collect the money. He also sends the parents Larry's ear. Henry is caught, but Larry is never found. Henry is charged with intentional homicide. So we have to go through the elements. Intent. Yes, we have mens rea of intent. Actus reus, one person taking the life of another. We don't know, right? Do we know if there is death? Do we have harm? All we have is an ear. Can a person live without their ear? So if we don't have a body, can we charge Henry with murder without a body? How do we show that Henry's actions killed Larry if we don't even know or have evidence that Larry is actually dead? So this happens sometimes. If you never find a body, it gets very, very, very hard because of the Corpus Delecti rule to actually charge with a homicide. So that becomes problematic. Now, you may charge them with kidnapping or multiple other offenses, but it will be very, very difficult to prove homicide without the body. Okay, now what happened with common law? We just had two choices, murder and manslaughter. So intentional murder, lower level mens rea, manslaughter. States didn't like that. It was such a severe distinction that they wanted some different degrees. They wanted additional degrees of murder. So they came up with different levels of murder. So we have murder still an intentional crime, but it's going to be different degrees. So common law broke murder into first degree and second degree. And then they came up with another type of murder called felony murder. So we're going to look at each of these. So the first one is murder first degree. With the definition under common law for first degree murder, you had intentional unlawfully killing another human. So intentional homicide, right? Intentional, one person taking the life of another. But to be first degree, common law added an additional element, malice of forethought. So in order to charge first degree murder, not only do you have to have an intentional killing, you had to also add these elements of malice of forethought. So malice has been defined a severe, intense hatred. So you have to have this malice, this severe hatred. You're evil. It's like a really super evil heart. You also had to prove a forethought. A forethought means you thought and planned it out ahead of time. So the only way to go to the highest level under common law was intentional homicide, so intentional taking the life of another person. But you had to show this malice and a forethought. If you didn't meet all of those things, malice, a forethought, intentional, and taking the life, you could not charge first-degree murder, okay? But what about this? A workman is the top of a 25-story building, gets angry at his boss, and just can't take it anymore. He takes a large, heavy beam and throws it off the top of the building onto a very busy road, striking and killing a pedestrian. So, can we prove intentional malice of forethought in this case? So we do have one person taking the life of another. You could have causation showing that they are linked. You have death. But do we have that intentional and malice and a forethought? Did he plan it out way ahead? Did he really intend to kill somebody? Probably not. It's probably falling down to more of a knowing. And you also don't have malice of forethought. He didn't really, or whoever it is, didn't really have malice towards the person he killed. He just was frustrated and he just threw something off the building. So this wouldn't necessarily fall under first-degree murder. So they had to create another crime, and this has been defined as murder second degree. So murder second degree is still one human taking the life of another. So it's the elements, the Actus Reyes of homicide, and it's with a depraved heart or mind. So depraved heart and mind has kind of become known as the knowing standard. So you kind of have like, you don't care if people live and die sort of attitude. You don't really care about what you do. So it really falls under more of a knowing mens rea. So under common law, if you could not prove intentional, you had to drop to this knowing mens rea. So let's test your knowledge if you understand the distinction between the two. So I'm shooting into a crowd or into an unoccupied building or car. Would that be first degree or second degree? So do I have malice of forethought? Am I specifically trying to kill one person? Probably not. Probably second degree. A child won't stop crying, so a parent shakes the child so hard that it causes death. Is that intentional malice of forethought? Probably not. Now, is it knowing, depraved heart? Is it likely that this could happen? So remember, knowing is intend to act, and it's virtually certain the results will occur. So in the first one, intentional act, and it's certain somebody could die if you're shooting into an occupied building or car. If you shake a child hard enough, is it virtually certain death will occur? Yes. So these are going to be more knowing types of mens rea. A driver running a police roadblock at a high rate of speed. So the police are blocking the road, and the person drives as fast as they can towards it and just plows through it and kills a police officer. Again, is this intentional? Maybe not, because there's no malice of forethought. It wasn't planned out way in advance. But it is a depraved heart. So if you're driving through it, you don't really care. You intend to act. And it's virtually certain if you do this, somebody could die. And then the last one, a golfer swings his club with such grace force, so the golfer misses and then just whizzes the club into the stands. Maybe you could say knowing. It's virtually certain if you do that, a metal object, you could kill somebody. Okay, so these would all fall more likely under second degree because you really could not prove that malice of forethought. Now, under murder, you also hear different terms. So the law also identifies different types of murder. So you may hear the term mass murder, serial murder, or killing spree. They have pretty distinct definitions. They're all forms of murder. But mass murder is killing multiple people all at once. So school shootings, the Holocaust, those kind of things, when you killed massive amounts of people all at the same time, that's considered mass murder. Serial murder is a little different. You do kill multiple people, but you have kind of a cooling off period in between. So you kind of find somebody, you kill them, then you look for another person and you kill them. So they're not all at the same instant, right? So there's this cooling off in between each of the murders. Now, a killing spree is basically when you're in the middle of a crime spree and you commit multiple homicides, all part of that same criminal spree. Not necessarily a cooling off period. It's just like one after another. So I get mad at my family. I kill them all. I go to school. Then I shoot up the school. That would be a killing spree. Then I drive down somewhere else and kill people. That's all part of the same thing. It's not necessarily serial murder, but it's a killing spree. It's all part of the same criminal act. Now, these are important later when we look at New York, because it's going to help us decide which degree in New York. So these are just the general common law definitions. Now, we said that we had first degree, second degree, but there was one more level of murder that we created under common law. So let's look at this. A woman sets fire to a home that she believes nobody is in at the time. Unfortunately, someone is home and that person dies. Can she be charged with first-degree murder? So we have to decide, did she have the intent to kill? Did she have malice of forethought to kill? And that would be really, really difficult, right? She didn't intend to kill. She intended to start a fire, but she didn't intend to kill. And then we have depraved heart, knowing killing. Do we even have that? Because, you know, you could say it's virtually certain if you set a house on fire that somebody's in, that somebody's going to die. But if she thought nobody was home, she doesn't really even fit depraved heart or knowing killing, because she intended to act and it wasn't virtually certain if she thought the person wasn't home. So it doesn't really fit perfectly in intentional killing, first degree, or depraved heart killing, which is second degree. But we still think this is bad because she really did still intend to commit a really bad crime, and the consequences were that somebody died. So what has happened is the law has created what they call felony murder. So felony murder messes with the intent, the mens rea, a little bit. So felony murder is a homicide, so one person taking the life of another, that occurs during the commission of what we call an inherently dangerous felony. So if you choose to participate in or commit a inherently dangerous felony, a crime that is very likely to hurt or harm people, then we're going to be able to charge you with felony murder, even if you didn't really intend for someone to die. So we look at your intent to commit the felony. As long as you intended to commit the felony, we're going to take that intent and put it on you for the taking the life of another person. So it doesn't fit perfectly in murder 1 or murder 2, but it's its own crime. So whenever you see somebody committing a felony and somebody dies, automatically think felony murder. Okay. So why do we have felony murder rule? Well, that's an interesting debate. Should we? So if you watched in the Parties to Crime, I had you watch a segment of this. So if you stop the video and you go back to that When Kids Get Life that I posted, now this time you're only going to watch segments 7 and 8. So if you start it right around 53.07 in segment 7, you only have to watch about 5 or 10 minutes. And it's going to talk about felony murder. So it gives a really great illustration of when felony murder occurs. And it may make you think, do we like this? Do we like felony murder? Is it a fair rule? So it's not that long. It's like 10 minutes, but it's really worth seeing because you can really see how this felony murder rule works And you can also see how it may be unjust sometimes in certain situations. So then the question up is, should we still have it? Okay. Now, so those are murder. So, but remember, common law had murder and manslaughter. So we now have given under common law some degrees of murder, first degree, second degree, and felony murder. So then we had to decide, is there any degrees in the manslaughter under common law? So what about this? Would a husband who catches his wife in the act of adultery and kill her be charged with murder? So we still have an intentional killing. So we have an intent, one person taking the life of another. So it could be either intentional, if you could show malice of forethought, or it could also possibly be knowing, depraved heart, depending on how the person was killed, right? But one of the things that happens in here is this husband basically freaked out, right? Sort of snapped. He didn't really think about it, plan it, no premeditation. He just saw something that was very disturbing to him, and he freaked out and he killed the person. So common law has created a separate category of crime called manslaughter. So this is one that doesn't really fit into murder first or murder second or felony murder, when it's going to be a lower level, like a knowing or a reckless, something like that. It's going to fall in the category of manslaughter. Now, the highest, so manslaughter is broken down into two categories. So manslaughter is without that malice, without that hatred. So you can have what's called voluntary manslaughter or involuntary manslaughter. So voluntary manslaughter is still going to be killing in the heat of, like, you still want to kill. Something happens that you freak out and you still want to kill. You still have an intentional killing, but you don't have malice, okay? And then the second category is going to be what we call involuntary manslaughter. This is when you have the reckless or negligent levels of mens rea. So let's look at this, it will make more sense. So voluntary manslaughter has been defined as an intentional homicide, so it's still mens rea intentional, and a homicide, one person taking the life of another. Okay, so it's still the requirements of murder in the first, but they added two other requirements: heat of passion, adequate provocation. So what the law says is, even if you intentionally kill somebody, if you do it while you're in this extreme emotional state and the victim provoked you into that state in some way, then you may not be charged with murder first. We may be able to drop it to this lower level crime, which is voluntary manslaughter, okay? So you have to be able to prove heat of passion, adequate provocation. So we need to think about what is enough to drive somebody to kill that would qualify as adequate provocation. So if you just call somebody a whore, is that enough to create adequate provocation to kill? What if you slap somebody or shove them? Can that stoke them into such an excited emotional state that they could kill? What if somebody gives you the finger, flips you the bird? What if you're being pistol whipped in the head? Maybe now we're probably getting a little closer, right? What if you shoot someone because they're walking through your yard? So is walking through your yard enough to adequately provoke somebody? What about someone shoots at you and misses, so you become so enraged you shoot back? So the court has to look at what happened to you and make a determination, is that enough to provoke you to murder? So we're dropping it from murder first down to voluntary manslaughter. Most of these would probably not qualify. Maybe being pistol whipped, maybe somebody trying to shoot at you, right? Then you could claim self-defense anyway. But so maybe these would be adequate provocation, but general normal slights, like giving them a finger, calling them a name, walking through somebody's yard, is not going to be enough for adequate provocation. So if you kill somebody, it's going to go back up to murder level if you don't have adequate provocation. Now, with voluntary manslaughter, we also have this thing called a cooling off period. So a cooling off period is meaning that there's this extensive amount of time from the thing that provoked you until the time that you did the killing, right? That you took the person's life. If there's a significant amount of time, the court could deem you as cooled off. So that means you're no longer in the heat of passion with provocation. You're no longer in that heat of passion. You've cooled down. So now if you kill, it's going back up to murder first or murder second, because you no longer have that provocation because you've cooled off. So let's look at this example. Flory's wife tells him that her father raped her. He walks all night to his father-in-law's home and kills him the next day. So we have to decide, was there a cooling off period? Now, you could easily make an argument both ways. First, think of it as a prosecutor. If you're a prosecutor, what would your argument be about cooling off? Well, yeah, he had plenty of time. He walked all night. He definitely had enough time to cool off. But if you're the defense attorney, now put your defense hat on. What could the defense attorney argue? No, the whole night he's walking, he's obsessing, he's thinking about it, he's living it over and over in his mind, that it wasn't enough to allow him to cool off. Now, why do we care? Because if you say you are cooled off, it's going to raise it to a higher level of homicide. So the punishment and sentencing is going to be significantly higher. If you do say there was cooling off, then it's going to, you say there's no cooling off, then it's going to drop it to the lower offense, lower sentence, lower punishment. Okay, so what are we looking at to determine between voluntary manslaughter or back up to murder first degree? Premeditation. So if the person premeditated, forethought, if they thought about it and planned it in any way, it's going to be first degree. If there's no heat of passion, if the person wasn't provoked in this excited state, then it's first degree. How was the person killed? If there was extensive torturing and things like that, it's going to go up to first degree. And then also a lot of times they look at the victim of the killing. So was it a police officer, a correctional officer, a judge, or a witness? If the actual victim is one of those things, we're going to raise it back to murder first degree. Okay, so these are the things that are going to help us determine between voluntary manslaughter, murder in the first degree, which you're going to have to do in a case study. You're going to have to read the case study and determine would it be murder first degree or voluntary manslaughter. So what about this? Fred owns a nightclub. One night when he was in the hospital recovering from a heart attack, one of his workers at the nightclub lights a match so they can get a better view of a burned out light bulb. Because of poor maintenance at the nightclub, the match ignites flammable decorations on fire. The fire spreads through the nightclub and kills several people. So is it a homicide? One person taking the life of another? Maybe, right? People died. Can we link the deaths to Fred's actions? Yeah, there is possible causation. But the question is, what level of homicide? Did he intentionally do it? No. Did he intend to act and it's virtually certain a fire is going to be created and kill tons of people? Probably not. So no knowing, so no murder second. Was he committing a felony while doing it? No. So no felony murder. Was he being reckless? Maybe. Was it a stupid mistake? Probably. So we can't really get any of the murder first, murder second, felony. We can't get, it's not intentional, so we can't get voluntary manslaughter. There was no heat of passion, no provocation. So the only thing we could get would be some level of homicide that was either a reckless or a negligent homicide. So we have a separate category of manslaughter for those two types of things. So unintentional homicides are what we're going to label as voluntary manslaughter. So voluntary manslaughter is going to be the negligent or the reckless forms of manslaughter. So if you can't show intent, premeditation, malice aforethought for first degree, you can't show depraved heart, you can't show heat of passion with provocation, and then you're down to a reckless or negligent homicide, that's when you're going to be in involuntary manslaughter. Okay, so think about the examples. A man is cleaning his gun when a neighbor walks in. The gun is loaded, but the owner does not know it. The gun accidentally discharges, killing the neighbor. So is this voluntary? Is this heat of passion, adequate provocation? Or is this a negligent / reckless type of killing? So probably involuntary manslaughter, a reckless, negligent type of killing. What about this? A woman is on her phone when her ex-husband climbs in her window screaming, "You ruined my life." He grabs her around the throat and begins to choke her. She grabs a kitchen knife and stabs him in the heart. So is that an intentional killing? Yes. But is it done with adequate provocation, heat of passion? Absolutely. She's freaking out when this is happening. Okay. It wasn't an accident. It wasn't reckless. She intended to do it, but she did it while in the heat of passion, while being provoked. So that's going to be your voluntary manslaughter. So as a review, we have covered 5 different levels of homicide at the common law level. Murder first is intentional homicide, one person taking the life of another, with malice aforethought. Murder second is depraved heart murder. So that's your knowing mens rea and then taking the life of another. Felony murder, you're in the middle of committing a felony and somebody dies, you can be charged with felony murder. Even if you didn't intend the person to die, you still intended to commit the felony. Voluntary manslaughter is still an intentional killing. You do want the person to die, but only because you were in the heat of passion and you were provoked. And then involuntary is going to be your negligent or reckless form of manslaughter. So using these 5 levels, read through each of these and see if you can decide which common law level it would be. So stop the video, go through all 7, try to label them, and then when you're done, turn the video back on and we'll talk about each of them. So hopefully you're back and hopefully you tried it. So the first one, Larry stalks his ex-girlfriend for 2 weeks and then stabs her when she exits her car one night. That would be murder first, premeditation, malice aforethought, right? Uri gets enraged when he sees his girlfriend talking to another man, so he shoots her. This is probably your voluntary manslaughter. It's an intentional killing, but in the heat of passion, adequate provocation. Eleanor kidnaps her professor and cuts his finger off before cutting off his head. So this is most likely murder first, right? An intentional killing, malice aforethought. You thought about kidnapping and killing. It also could be a felony murder, right? Because she's kidnapping and during the kidnapping, she's killing. So it's a felony type of murder. David kills an officer who pulls him over. It could be intentional, I guess, or depraved heart. It also could possibly be voluntary manslaughter. Maybe he was so enraged by being pulled over. I'm not sure the court would recognize that as adequate provocation, though. So it probably would be either intentional, if you could show any premeditation, if he had a beef with this officer from the past, so he planned it, or otherwise depraved heart, 2nd degree. Queenie burns down her neighbor's house. She thinks they're on vacation, but the son's still home, dies in a fire. That's going to be your felony murder. Sammy is driving a little too fast and kills a child playing in the street. That is going to be involuntary manslaughter. And then Zena is playing softball game and strikes out, throws her bat, strikes and kills a bystander. Again, that's going to fall under reckless or negligent. So that's your involuntary manslaughter. So hopefully you got all of those right. So if you have any questions about common law homicides, please reach out. So what we're going to do in the next segment is we're going to look specifically at New York law. So make sure you have your penal law with you for the next section. We're going to actually look in the New York penal law and start to look at how New York distinguishes between the different degrees of homicide. So I look forward to seeing you then. Have a good night.